Good evening. My name is Susan Peabody, and it's my privilege to introduce our next speaker, Justice Jeff Brown. He's a former judge of a district court. He's a former justice of a court of appeals, and is now a Supreme Court justice in Texas. He's here to speak to us, give us insight about the situation, the issues going on with minors seeking abortion. So with no further ado, Justice Brown, welcome.
Well, thank you very much, and thank you for the opportunity to come and visit with you all tonight. As you heard, my name is Jeff Brown. I'm the junior justice on the court right now. I am not on the ballot this time, so you're not going to get a campaign speech from me. What I came to tell you about tonight, and I know you have a full schedule, so I'm going to try and keep this brief and informative. In the last legislative session, the legislature, as part of its pro-life package of bills, passed a bill called House Bill 3994, which amended the judicial bypass procedures here in Texas, and I'll explain what those are. And I wanted to come and just last month, the court, after being charged with the legislature with amending the rules that administer those procedures, came up with a new set of rules, voted on them, passed them unanimously, signed an order at the end of December, and they went into effect on January 1st of this year. And so I came tonight to kind of tell you all about what the changes in those rules are, and that requires a little bit of history to get us started. Following Roe versus Wade in 1973, the U.S. Supreme Court handed down two more rulings that concerned state laws requiring minors to get their parents' consent or at least inform them before obtaining an abortion. In these two cases, Planned Parenthood of Central Missouri versus Danforth in 1976 and Bellotti versus Baird in 1979, the court, this is in the court's pre-Scalia, Alito, Thomas days, the court said that states could not require parental consent or even mere notification unless they also provided an alternative procedure by which an abortion could be obtained. The U.S. Supreme Court also set forth 4 requirements that any bypass procedure must meet. The procedures must allow the minor to bypass the consent requirement if she establishes that she is mature enough and well enough informed to make the abortion decision independently, must allow the minor to bypass the consent requirement if she establishes that the abortion would be in her best interest, must ensure the minor's anonymity, and provide for an expeditious bypass procedure. Now, you may be wondering where any of those words appear in the United States Constitution. They don't, but the court at that time and to a large extent still today finds things in the Constitution that aren't there. It was 1999 before Texas attached any restrictions on a minor's ability to obtain an abortion without her parents' knowledge or consent. And even then, all the legislature did was require notice to parents, not consent. It prohibited a physician from obtaining an abortion without 48 hours notice to the minor's parents. To even require that, however, under the cases handed down by the United States Supreme Court in the 1970s, the state had to provide a bypass procedure, and so it did, a way for the minor to go and get the abortion even though she had not notified her parents that she was seeking one. Minors could go to a judge to get around the notice requirement. In 2005, the legislature changed the requirement to a consent requirement from mere notification, which also could be avoided as required by the U.S. Supreme Court through a judicial bypass procedure. Under both the 1999 and the 2005 legislation, the legislature charged the Texas Supreme Court with the duty to draft procedural rules that would govern the bypass procedures. As part of the pro-life package of bills the legislature passed last year, the bypass procedure was amended again. And again, the legislature charged the Supreme Court with implementing the amendments by amending the procedural rules governing bypasses. Last month, the court finished drafting and approved those rules and signed an order making them effective on January 1st of this year. It's those new rules I'm here to tell you about tonight. And here is a list of the most significant changes to the judicial bypass rules. First, because of the way the legislature drafted the 2005 amendment, there were still lingering references to parental notification rather than parental consent. Those references were done away with, so that it's now crystal clear throughout the statute and the rules that consent is required and that mere notification is not enough. Under the old system, a minor could seek a judicial bypass in any county in Texas. No matter where she lived, she could go and pick the county where she wanted to try and seek the bypass. And these girls, there's an organization called Jane's Due Process that helps them go and seek these bypasses. Now, under the new rules, except in limited circumstances, the minor must seek the bypass in her county of residence. And this change was made to prevent forum shopping for a friendly judge. The minor also must now make a sworn statement that the claims about her county of residence and any previous attempts to obtain a bypass are true. She must appear in person before the judge rather than remotely. Under the new law, the judge had 2 business days after the bypass application was filed to issue a ruling. Now the judge has to rule by 5 p.m. on the 5th business day after the application is filed. Also, and this is very, very important, under the old law, the burden of proof on the minor to show what the U.S. Supreme Court said must be shown to obtain the bypass was a preponderance of the evidence, the lightest burden required under the law. Now the burden of proof on the minor is by clear and convincing evidence, a heavier and much more difficult burden to satisfy. And under the new rules, the application can't be non-suited without the court's permission. And what that means is the minor, assisted by Jane's due process, can't file an application, see that she's got a judge that's going to hear it who is likely to deny it, and non-suit it, dismiss it herself, and go and try and find another place to file it. She can't do that now except with the judge's permission, and that was also meant to prevent forum shopping. Also, under the new rules, a trial court's ruling on an application for bypass is given res judicata effect, which means once it's decided, it can't be revisited by another court and overturned. The only exception is that the minor can seek a bypass for a second time from the same judge that denied the first bypass if it can be shown that there has been a material change in circumstances. And under the new rules, a judge or justice who reasonably believes that a minor seeking a bypass has been physically or sexually abused is required to report the suspected abuse. And the new statute also provides that the Office of Attorney General may initiate an action to pursue a civil penalty of between $2,500 and $10,000 against a person who is found to be in violation of the statute. Finally, under the old law, if the judge failed to rule by the deadline, under the old rules it was 2 days, under the new rules it's 5 days. If the judge failed to rule by the deadline, the application for a bypass was deemed granted. Under the new law, that deemed granted provision was removed, but the legislature didn't replace it with a new provision. The new law is silent on what happens if the judge neglects to rule on the application. Well, the rule that the Supreme Court issued has covered that discrepancy. It says that if the judge doesn't rule by the deadline, the application is deemed to have been denied. This is one of the most significant rule changes, and it's one that the court made without express instruction by the statute. Something had to be done to keep the ruling out of limbo, and so the court held the application should be deemed denied. That's how other requests to trial courts are typically handled in the rules of civil procedure. If the court doesn't, such as when a person files a motion for a new trial in a case, if the court doesn't rule by the deadline set forth in the rule, the motion is deemed to be overruled as a matter of law, and that's exactly what the court did in these new bypass rules. As I said earlier, these amended rules were approved unanimously by the court last month and went into effect on January 1st. Upon their approval, the legislative director of Texas Right to Life issued this statement. Texas Right to Life applauds the Supreme Court of Texas issued amendments to the judicial bypass rules. Particularly, we fully support the court's effort to provide clarity to the vital issue of what happens when a judge fails to rule within the required 5-day time period. Ending the automatic granting of bypass petitions was a top priority for Texas Right to Life. And because of our advocacy, the Texas legislature ended the ridiculous practice. However, we appreciate the Supreme Court of Texas clarifying that a petition is automatically denied if the judge fails to rule within 5 days of the hearing. He added this is a common sense policy that matches virtually every other judicial process in Texas and will stop the abortion industry from manipulating the court system to usher minors to elective abortions without any parental involvement. The last thing I'll say is that with just about every other new pro-life restriction that Texas adopts, these rules are fully expected to be challenged in federal court. So I hope you appreciate the hard work that the court does, that it is able to do on this issue, and thank you very much for your support of the court and everything that it does. Thank you very much.